started, Kathleen, I'm introducing Kathleen Summers, our attorney. She will be doing our monthly presentation.
Oh, wonderful. Thank you, Allie, very much. And again, good afternoon, everyone. So today we're going to be talking about blended families and yours, mine, and ours, and some of the unique things that we need to consider from an estate planning standpoint when we're dealing with blended families. So why don't we go ahead and begin? One of the places I always like to start is just a reminder about what basic estate planning looks like, regardless of your situation. So whether you're in a blended family situation, you're a single individual, married couple, whatever, there are basic documents that everyone should put in play. And then we're going to talk about how those documents really play into a blended family consideration and become more important, particularly as we age. So one of the first places we start is always wills. A will, remember, is a document that is like an instruction sheet. It tells us what to do with assets that you own individually at the time of your death. Assets that don't have either joint owners or have a named beneficiary. So when you pass away and you have assets that are in just your own name, we don't know what to do with those assets. And that's where the will comes into play. A reminder to everyone that wills always require a probate proceeding. So if at the time of death there are assets in just your own name, we again don't know what to do with those, and the laws of the Commonwealth will come into play if you don't have a will. And if you do have a will, then the will itself will direct what happens to those assets. But either way, we do need to involve a court and we need to involve a probate proceeding. And I'm going to talk about why that's an important consideration because as we go along in the presentation, you'll see that that opens the door to being able to claim certain benefits if you are the spouse of a deceased individual that may or may not be what that individual had intended. So wills are critical to be able to help direct how you want things to pass after your death and who you want to be responsible for managing your estate. We call that a personal representative. Used to be called an executor, but it's the same thing. Another document that's critical is the durable power of attorney. This is where you're naming someone of your choosing to step into your shoes to manage all aspects of your life, mostly financial things. And it really handles all decision-making but healthcare. So powers of attorney are very powerful documents. They oftentimes can give the ability to be able to sell property that you own, to be able to change beneficiary designations on assets. It may also give the ability to create trusts or adjust trusts, amend trusts that you may have created during your life. So want to be able to really look at a power of attorney with respect to a blended family situation and make sure that the powers in that document are ones that you do want to give to someone else. Another document that everyone should have in place is a healthcare proxy. This is like a power of attorney, but it is for healthcare decision making. It becomes effective only if you become incompetent or incapacitated. And this is a document in which you're appointing somebody to step into your shoes to be able to manage healthcare decision making in the event you are unable to communicate or make your own healthcare decisions. And then there are trust documents. They're not a have to in any estate plan, but they can be very useful. And particularly in the situation of blended families, trust can provide for loved ones like a second spouse, or they can provide for the children, let's say, of a prior marriage, by also making sure that we're taking care of everyone else in a way that is going to be fair and equitable, at least with respect to what you believe is fair and equitable among the individuals, and can help to really avoid things like probate and potentially even avoid some potential issues between individuals after your death, let's say. So a trust in a blended family situation can be extremely helpful, and I'm going to talk a little bit more about that as we go on. So let's begin by talking about what happens if you don't have any estate plan in place. So you don't have wills, you don't have your powers of attorney, you don't have your healthcare proxies. Well, with respect to while you're alive, if something happened to your ability to make decisions for yourself, One thing to remember in Massachusetts is we don't have an automatic ability for a spouse to be able to step into your shoes. Now, if you jointly own assets together, like a bank account, savings, checking account, an investment account, certainly the joint owner, the spouse, would be able to do with those assets what they choose. But things like property, real estate, also things like your retirement plans, 401ks, 403bs, IRAs, etc., your spouse isn't automatically able to step forward and make decisions for you. So making sure that a power of attorney is in place, naming the person of your choice to be able to go into that position should you be unable to do things for yourself is critical. Without an estate plan in place, we're talking about having to go to a court and get a conservator appointed. And there is no guarantee that someone like your current spouse will be the person named to manage your affairs under a conservatorship proceeding. Conservatorship proceedings are also extremely expensive, and they involve a court, and that becomes one of the last resorts if we can help it. We'd rather have you have the ability to name who you want to step into your shoes. And another thing you want to discuss with an attorney is, again, with that power of attorney, what the breadth of authority is, and if you might want to in any way tailor that authority to make sure that your new spouse isn't able, let's say, to change the beneficiary designations on something like a 401k. Now, when we take something out of a power of attorney, there's always a consequence in the sense that it limits then what that person might be able to do for you, but there can be good reasons why we might want to limit the power of attorney under those circumstances. Another document that's critical that if you don't have in place, your healthcare proxy, and something happens to your ability to be able to manage healthcare decisions for yourself, we have to go to a court and we have to get a guardian appointed. Very much like a conservatorship, this is a court proceeding, and you don't have control over who would necessarily be in the position of making healthcare decisions for you. So talking about these things ahead of time, getting the documentation in place is critical. If you die without a will or a trust, and there's nothing directing how your assets are going to go after your death, then you die what's called intestate here in Massachusetts. And it's a fallacy that your spouse is going to end up with everything. So one of the things that you need to know is under intestate laws, particularly if you have children from another marriage, let's say, those children may have a claim on the estate as well as your current spouse. And so understanding that there might be an unintended consequence to dying without a will in place is important. You're not directing how your assets to go. You're not making sure that the person that you want to manage your estate is being appointed to be able to do that. So dying without an estate plan in place can have very much unintended consequences for what you would like to see happen. And it also can set things up for a lot of discourse between family members. So let's talk a little bit more about what happens when either we die without an estate plan in place or if we use wills as the basis of the estate plan. So one thing to remember in Massachusetts is that a spouse always has what we call an elective share. So if you are married and if you are separated, let's say, or this is a second marriage for you, one thing to remember is if you die without clear direction through a will or a trust, there's always something called an elective share that a spouse can take. So an elective share gives them a basic amount of value out of the estate, even if you chose to disinherit them. And so understanding how the elective share works here in Massachusetts is critical to understanding what would happen when you leave your assets through particularly a will. The other thing to know is, again, the intestate laws. If you die without any kind of will or trust in place, so you have given no direction at all with respect to your assets, the intestate laws will take over. And this is, again, dying without direction for us to understand how you want your assets to pass. Your spouse may get a portion of your estate, but they may not get all of your estate. For instance, if you have children from a previous marriage, those children may take a portion of the estate. Sometimes if you pass away and only have a spouse, but you have parents who have survived you, they may take a portion of your estate. So understanding that there's unintended consequences in terms of who may inherit the estate is critical. One of the things that people often forget is that estate planning doesn't affect things like what happens with joint ownership. If you own an account with someone else, so you have an account, let's say, with your spouse, but you really want a portion of that account to go to your children from a previous marriage, maybe, or one thing you have to understand is that joint ownership is going to really trump whatever might be your wishes. It's going to go to the surviving spouse in that case. They are the joint owner. And so no assets will end up passing, let's say, to children of a previous relationship or anyone else that you might want to provide for. So understanding how you own your assets is critical to the planning process to understand what's going to pass through a will or a trust and what is not, what's going to go directly to the joint owner that's named. The same thing happens with beneficial designation. So if you have a retirement plan and you have named a beneficiary on that plan, that beneficiary will receive that retirement plan regardless of what your will or trust may say. So when going through estate planning, it is very critical that you take a look at your asset holding, if there are other names on those assets as joint owners, and understand the consequences of that, and certainly understanding your beneficiary designation. One of the things that we see is we had a change back in Massachusetts back in 2012. We brought in what's known as the Massachusetts Uniform Probate Code. And this changed some of how we were handling assets after an individual passed away. Under that, one of the things that was affected is what happens when you have a divorce or a remarriage. What happens to a previous estate plan that you might have had? So there have been changes made, and I'm going to go through a little bit about how those things come into play. But one thing to remember is that if you have named beneficiaries on assets like a life insurance policy, let's say you named your previous spouse, or even something like in a retirement plan, it remains your previous spouse in terms of a beneficiary designation. That beneficiary designation will be upheld after you pass away, and that might not be what you intended to have happen to those assets. So it's critical after you have a change in your marital status that you look at your joint ownership of assets and you look at your beneficiary designations and make sure that they're reflecting your current wishes. So if you have an old estate plan in place, what does happen to that with respect to either a divorce or to a remarriage? Well, one thing to remember is that a new marriage doesn't revoke a previous will. Now, the divorce may have effect on the will. For instance, if you named a previous spouse to be the beneficiary under your will, that designation will be treated as if that previous spouse predeceased you. Unless you wrote the will after your divorce. But the new marriage doesn't automatically put your new spouse in the position of where your old spouse was within your will document. So it's critical that you update any estate planning documents that you have to ensure, again, you understand how things are flowing and who's going to benefit. The other thing that's critical is making sure that you've appointed the person or people that you want to be in what we call the important fiduciary positions under the documents. Who's going to manage your estate? Who's going to make decisions for you if you're unable to make them for yourself under a power of attorney? Who's going to make your health care decisions under a health care proxy? You want to make sure that those documents are updated and that, again, 10, 15 years down the road, some event happens and an ex-spouse ends up being called in to make a healthcare decision for you. That's not what you most likely want to have happen. And really, again, understanding what value a new spouse may be able to claim under the elective share or if there is no will in place, what the intestate laws are going to look like in terms of who's going to get what. So if you have a current estate plan in place, you really want to make sure that you review that carefully and that you review again all of those beneficial designations and all of the joint ownership of any kind of asset holding and how they're going to flow. So some of the things that you need to think about when you are starting to do estate planning after you've had, a remarriage. First of all, what assets do you want to leave to children? That's something we all need to think about when we're doing estate planning and we have children, is what assets are we leaving to our spouse and what control are we leaving with our spouse? And is there a desire to leave things to the children and in which way? Are you going to be leaving things to the children only after you've taken care of your spouse? Or particularly in situations in which you may have children from a previous marriage or relationship, do you want those children to be provided for even though your spouse may survive you? So some of the things you want to take a look at is how are you providing, if at all, for children? If you're planning to have more children, how are you providing for those children, and is it different than what you're providing for children from a previous relationship? You want to make sure you're very clear about that. You may have children who are older, who are now adults, and then you have children from a new relationship that are younger, and you may want to provide for them differently. For instance, our older children, when we may have already put them through college, let's say, or helped to provide for different things like helping them with down payment on a house or repayments of loans, etc. And we want to somehow equalize that off with the newer children to make sure they still get a somewhat equal benefit as the older children did. Or you may say, no, I want to make sure that I'm providing for the children in a different way. And maybe the children from a previous relationship, you want to take a look at what other financial means they may have or support. And you may say, I'm providing for the new children up until a certain age or ages or completely, and not necessarily leaving the same amount to the older children. So thinking this all through is critical and making sure you have conversations about it so that you're both on the same page. Assets that you want to continue to hold individually. When you remarry, there may be assets that you brought into the marriage that you want to make sure continue to be held by you and controlled by you for one reason or another. Now, there are ways for us to be able to, let's say, create a trust that might hold those assets for the benefit of the other spouse, but keep the ultimate disposition, how ultimately those assets are going to flow under the control of the first spouse. So let me give you an example. In a remarriage, let's say there are children from the first marriage of the husband, and new wife and husband, they now have children as well. And the husband brought in assets that he wants to make sure, like a property. Let's say there's a home, and he wants to make sure his new spouse can continue to live in that home for a period of time, maybe even lifetime, but we can talk about what some of the consequences are of that or complications of that, but ultimately wants the value of that asset to go to his children from his first marriage or to be split among all of the children. There are ways to be able to create that kind of situation under a trust to make sure that the new spouse has a home to live in, has a place to be able to continue to reside, but the ultimate value of that property going, let's say, to the children. Then you want to talk about what assets are you going to hold together. So maybe in this remarriage, you didn't have a home previously, but you bought a home together. And both of you are adding to the value of that home and carrying the cost of that home. And so you want to make sure that value doesn't end up going to, let's say, children of a previous marriage. So thinking these things through and thinking about how assets are held and how you want them to end up being divided or disposed of after your death is critical. Otherwise, again, if you don't think about this and you bought a new home, let's say with your second spouse, but it really was your money that paid for that, and it was your intent that that house eventually provide for your children from your first marriage, your spouse if they're joint owner on that property and you die first, is going to control what happens to it. And if maybe they said to you, of course, I'll take care of your children, but life changes, as we all know, things happen. They have the ultimate control as to whether they're going to honor that or not. And they may decide, no, they're not going to provide for the children of a previous relationship. One of the things that oftentimes people forget when they're thinking about bringing assets together and blended family situations is debt. If one of you comes into the marriage with more debt, you really want to think about, how is that debt going to be handled? Is this something that you're going to work together to pay off and you're willing to use your assets to pay off your new spouse's debt? Or is this something that you say, no, we're really keeping separate, both now as well as potentially if something happens to our marriage or upon the death of one of us, not wanting that debt to be, saddled with the other. So really taking a look at what you're bringing in, not only from an asset standpoint, but from debt, to make sure that you're clear about how those things are going to be handled. Prenuptial agreements are absolutely something to consider, particularly in a second marriage situation, but even in first marriages, to be able to address a lot of these issues ahead of time. A well-written prenuptial agreement can really provide a nice roadmap for how you all want to do all of this, how you want things to flow, not only during the course of your marriage, but certainly after the death of one of you, and can really help to have you think through a lot of these questions ahead of time and get your thoughts clear and in writing and an agreement between the two of you so that it doesn't come up as an ongoing issue as you move forward. So certainly, and if you have any kind of a prenuptial agreement in place, you want to make sure that that's shared with your estate planning attorney so they can make sure the plan follows that prenuptial agreement. It's the same thing if you have any obligations under a divorce agreement. As we're going through estate planning, we want to make sure we understand what those obligations are and that they're incorporated into your estate plan, so that if you became incompetent or you pass away before the course of that divorce agreement ends, that the obligations are clear and fulfilled in the way they need to be to help stop any kind of ongoing court issues that may come up or the lack of someone following the obligations under a divorce agreement. And then stepchildren. If you are entering into a marriage and there are children from another relationship for your new spouse, are you going to be planning for your stepchildren? Is this an expectation that, no, this is something that their parent will take care of? And as the step parent, you're not going to be responsible for future obligations to those stepchildren? Or has the decision been made that, no, you will make sure that you provide for the stepchildren as well under your estate plan? Again, one thing to remember, estate plans are always revocable, changeable as time goes on. So in a second marriage, if there's an agreement between the spouses that of course you'll take care of each other's children, after one of you dies, in many circumstances, the survivor is going to be able to change certain aspects of their estate plan and could decide not to follow what they had agreed to do. So you want to talk with an estate planning attorney about whether things are changeable and amendable in the future, or whether things can be put together in such a way that they are not changeable by the surviving spouse. So let's talk a little bit about some of the considerations if you do have children from a prior relationship and you want to protect those children. So talked a little bit about this, but again, in most, let's say, a long-standing marriage in which the children are the children of the two of you, oftentimes we plan so that you take care of your surviving spouse first, and then the children will receive something after the surviving spouse dies. In a blended family situation, that may need to be looked at and adjusted. For instance, again, if you have children from a prior relationship and you've entered into a new marriage, you want to take care of your spouse, are you doing so with the intent that the children will wait for their inheritance, with the possibility that there is nothing that's left after the surviving spouse dies? Or do you want to make sure that there are assets that go to the children of the prior relationship at the time of your death, regardless of whether your spouse survives you or not? So something that you want to really consider is, how are you providing for children of a prior relationship, and when? Do you want the surviving spouse to be able to alter the plan? So I had mentioned before, let's say you're just using wills, and let's say you're using a typical type of will that's just leaving everything to your spouse. Well, if you die first and you're leaving everything to your spouse, you are relying that that spouse will take care of the children of a prior relationship if that's your desire. If you don't make sure it's clear how those children are going to be taken care of, and you leave the ability for your surviving spouse to change or amend things, they may decide to cut the children out from the prior relationship, and they would have no obligation. So making sure that you have that conversation, and again, decide when those children are going to be taken care of, how they're going to be taken care of, and making sure that if it's important to you that they are taken care of that way, that you don't leave the ability for the surviving spouse to amend the plan with respect to those children. Trust can be set up in a way that we can preserve asset holdings for children in the future, but take care of the spouse in real time. So let me explain that. Let's say again that you have a home and you want to make sure that upon your death that your new spouse can stay in that home for a period of time. You can write a trust in such a way that you give the right of occupancy to the new spouse over a period of time. You have to talk about who's going to be responsible for maintaining the house and who's going to be responsible for expenses related to the house. But then make it so that when the house does sell, and again, you can even define what that time period would be, that then the children from a prior relationship would get some of that value or all of that value, depending on how you want that to proceed. So you can use particularly trust as a way of holding assets, providing for your current spouse. So you put money into a trust. You could give income to the current spouse for a period of time or for their lifetime. You could even give access to principal under certain circumstances to that new spouse, and then make it so that what remains in that trust at the time of the second spouse's death, that it goes to the children or it gets split in whichever way you would like to see those assets to be disposed of after the second spouse dies. One thing you have to remember about trusts is they require what's called trustees. This is who's going to be responsible for managing those assets and making those critical decisions. Oftentimes, we don't want that person to be the surviving spouse. We want a third party. That might be a trusted friend. It might be a relative. It could be a professional. But oftentimes, we do want kind of a third party in there managing things so that we don't have a problem with the surviving spouse being caught both managing the trust and being a beneficiary of the trust, particularly when we want assets to be left for others like previous children. And then you have to think about minor children. If you have children who are under the age of 18, this is going to require some kind of a guardianship to be considered if you pass away before that child reaches the age of majority. And who's going to end up being that guardian? And you want to make sure, again, you're coordinating and discussing who's going to end up taking care of that child until they hit the age of 18. So let's talk about some ways of protecting the surviving spouse. So we talked about taking care of children from a previous relationship, but how do you take care of your new spouse as well in terms of your estate plan? One of the things is housing. That's a big thing to be thinking about, whether you've bought a home together or whether one of you comes into the relationship with real estate in which both of you are now living in. How do you make sure that that surviving spouse is going to be able to, A, keep living in the house, keep being able to afford the house, etc.? So let's take the example where one of you brings in property into the new marriage, and you both reside there, you both are taking care of, let's say, the expenses, or maybe even one of you is just covering the expenses, but the owner of that property is the first to die. And let's say there are children from previous relationship for that individual. Well, what happens to this asset? Is the intent that that property is going to go to the new spouse, and then now it's part of their asset holdings, and it may not provide for the children in the future? Or maybe the intent is to leave it so, again, the surviving spouse has a time period, whether that be a period in years or whether that be, let's say, for the remainder of their life, to be able to live in that property. Then you have to think about how is that property going to be maintained, who's going to be responsible for what bills, etc. And you can make it so the value then, either after the death of the second spouse or after the time frame has expired, goes to the surviving children. But you have to remember, you're then setting up a situation in which the children are waiting for their inheritance, number one. And it could cause friction between the children from the previous relationship and the new spouse. So you want to think about all of these things and what's the best way for everyone to move forward. You also can set it up so, again, you have income, let's say, or limited access to principal value if we're talking about cash holding for a surviving spouse, while making sure the remainder of that principal goes to children after the surviving spouse has died or after a period of time. So we can do this both with real estate and we can do it with assets such as investments, providing for each other, providing for the new spouse while still making sure asset value goes to children at some point in the future. Long-term care is a huge thing. As we age, who's going to be responsible for paying for long-term care? How are you going to lay that out? Are you expecting each other to take care of each other as you age? And thinking about all of the different decisions that have to go into long-term care, making sure you have your healthcare proxies updated so your decision makers are the people you want them to be, should you not be able to make decisions for yourself. Critical things to think about. And one of the things you'll see here is like avoiding that conflict between spouse and stepchildren. You know, is there an expectation that the children from the previous relationship are going to step forward and provide the care, or the new spouse to provide care or to help pay for care? How is that going to be handled? So things like a long-term care come into play for traditional families as well as we age, but with blended families, they become more heightened because you've got sometimes people with very differing kind of goals in place and in terms of what's going to happen with long-term care costs, which can eat up a tremendous amount of asset holdings. Talking about the long-term care, disability, and illness planning, again, making sure your powers of attorney in place, making sure your healthcare proxies are in place. Having conversations about this, if you can ahead of time, is really critical so that everyone's on the same page. Again, thinking about who's going to be responsible for what and what the expectations are of all parties as you go forward. Possibly looking to, you know, how do you fund care for each other without, if the intent is to leave assets for children as well, how do you do that without draining their assets? A lot of times when we have a married couple, things like what we call 11th hour Medicaid planning, that's where you apply to the state under the Mass Health System to have something like long-term care paid for, involves the transfer of assets from one spouse to the other. But if we transfer assets from one to the other, now making it so, in this case, the healthier of the two spouses holds all the assets, remember, it's their estate plan that's going to control what happens to those assets. And you may end up, you know, either purposefully or not, cutting out children of the other spouse and them not receiving what you otherwise thought they were going to end up receiving. So thinking these situations through ahead of time, if possible, if you're young enough to consider things like long-term care insurance and how that might come into play to help, or how you're going to keep assets held separately and coming in and putting together something like a prenuptial agreement to make sure that you've got clarity over who's going to be responsible for these long-term care costs. One thing on the long-term care, if I could, let me just go back, talking about HIPAA. Make sure that if it's important to you, again, we never know what the relationship between everyone will be, and we never know what it will be, particularly in the crises. So if it's important to you that your children from a previous relationship have the ability to be part of conversations regarding your health care, access to your physicians, et cetera, putting something in place like a HIPAA authorization and release form is critical to make sure all the parties that you want to have as part of that conversation are able to participate and that nobody's being purposefully, let's say, left out. And the last point I really want to make about all of this is that no planning is, a silo unto itself. Planning is really very comprehensive. And you want to think about things too, like what happens at funeral arrangements. I always say to clients, it's not necessarily a fun way to spend an afternoon, but particularly in blended families, at the death of a loved one, it can really cause a lot of friction if everyone isn't on the same page or everyone isn't clear as to what your wishes were at the time of your death, how you want your funeral arrangements to be handled, where you want to be buried, who's going to be able to participate, etc. You want to think about that ahead of time and even arrange that ahead of time if you can. Local funeral homes here in Massachusetts are very adept at being able to put together irrevocable funeral contracts so that you've got clarity about what your wishes are and how that's going to be honored. The distribution of personal property. So let me give you an example. You remarriage, you have children again from a previous marriage, they're now all adults. You've been living with your spouse, let's say, for your second spouse for 10, 15 years. You've gathered personal property together. You don't want it at the time of your death to become a volatile point as to who gets what. Where's grandpa's pocket watch? Who's going to get that? Your new spouse? Does that go to the children? How does that all get played out? So a lot of times we think about in estate planning our real estate and we think about our bank accounts, our financial assets, but we forget about the personal property, which oftentimes can become such a sparking point when someone dies because there's often sentimental value given to those assets, and everybody seems to want, as they say, grandma's yellow pie plate because she made the best pie. And even though grandma's yellow pie plate has no value or very little value, it's the sentimental value that seems to get in the way. So being very clear about personal property when you can, and what assets are going to your spouse and what assets, if any, are going to, let's say, children of a previous relationship. Look at those beneficiary designations, make sure things like your insurance policies, life insurance policies, all have clarity around who the beneficiaries are and that they're up to date. And consider even using products like life insurance if you can, depending on your age and health situation, to maybe provide value for someone after your death. For example, let's say you have a home that you have with your new spouse, and this is something you want to make sure goes to your new spouse, but you put value into that home that you want to provide for your children with. A way of doing that is possibly to look to purchase something like a life insurance policy that might be able to make up the value that you could give to your children while still giving the property to your new spouse. So considering some different ways of being able to provide value to those who you love without making it so the children might have to wait until that property is sold to get their inheritance may be a good compromise, a good way of meeting your goals, and really being able to keep some sense of, peace and just kind of community between your family members. And going back to those long-term care costs again, they're a critical component that we oftentimes forget. Again, looking at something like a long-term care policy to figure out whether that might be a way to help to pay for and provide for care in the future if you need it. You need to look at what that policy provides, what its cost structure is, and if you even can get one depending on your health and your age. But it can be a nice option along with something like life insurance to be able to be part of an overall planning option. So thank you. I don't know if we have any questions that anyone may have. Well, fantastic. Well, I hope that was helpful to everybody. Thank you so much for joining us today, and look forward to seeing you all the next time.
Thank you, everyone. Have a wonderful afternoon.